Good afternoon. Welcome to another episode of Digital Transformation Thursdays. I'm attorney JJ Ticini. I'm the managing partner of Ticini Law Office. As you may already know, we're holding a series of webinars called Digital Transformation Thursdays to celebrate the 20th year of our firm. We were founded in May 2000. And this is, I'm not sure which episode this is, but I'm very excited about the topic today. And it's very, very relevant to all the changes that we've seen since the pandemic started. So all of us have had to adjust to the pandemic, and arbitration is no exception. And that's what we will be discussing today. Perhaps some preliminaries. As I always say when I welcome you, if you please post on the comment box if you're on Facebook, or the chat box if you're on with us in Zoom, about where you are right now, and then we will do a shout out later. I always like to see whether or not we're getting people from Luzon, Visayas, and Mindanao. So we were able to do that last time, so we're very happy about that. And we'd also like to inform you that if you want to receive an e-certificate for attending today's session, please make sure that you sign up at our DTT, at the DTT website at dtt.ph. You sign up on the Zoom registration, fill up the Zoom registration form, and you will receive an email. And as you know, we contribute the proceeds that we get from your donations for the e-certificates under DTT Donate, and we donate it to COVID frontliners. And we thank you for that, and we thank our speakers as well, our guests who have contributed their time for that purpose. Okay, so I think that's it. We'll go now to our topic, which I'm very excited now. I don't count myself as an arbitration expert. I've been watching in the sidelines. I believe it's a very interesting, certainly a very interesting mode of this alternative mode of dispute resolution. There have been a lot of arbitration in the Philippines, but I think a lot of the arbitration of Filipino companies and Filipino entities happen abroad. But certainly the pandemic, in much the same way that the courts have adjusted in doing remote or electronic courts, the same thing has happened in arbitration, and we have two very distinguished speakers today to discuss this as it is rolling out in different parts of the world. And they will speak as to their perspectives. And it's actually quite amazing that we have our first speaker is coming all the way from Paris. She's Dr. Maria Hauser Morel. She's counsel at an arbitration firm called Hanefeld. She's a graduate of law from the University of Poznan in Poland, and earned her Master's of European and International Business Law from the University of St. Gallen. And she acquired her Doctor of Law at the University of Wrocław in Poland as well. Prior to joining Hanefeld, she headed a case management team at the ICC, covering Central and Eastern Europe, and currently acts as counsel and arbitrator in international commercial arbitration cases. Please help me in welcoming Dr. Maria Hauser Morel. Maria?
Hello from Paris.
Hello. So it's morning right there, and so
it's morning. It's 9 a.m. So not as early.
Good morning then. Okay, so you can share your screen, so you can start.
I can, unless you want to. So we have Janice with us as well, and right. But you want to introduce her later.
I'll introduce her later, yes.
Okay.
All right.
Welcome, everybody. If I manage to share the screen, that is because we are up. Had to get used to it. Is it working?
Yes, it is.
Is it working? Okay,
yes.
Well.
Thank you.
So I will speak today to you about digital transformation in the sphere of arbitration. And I will talk about, there'll be two parts in my presentation. First, in general, the current transformation that took place in the sphere of arbitration in terms of digital means, and then I will try to speculate as to what will be the future of arbitration after COVID in terms of digital transformation. So for those of you who are less familiar with arbitration, it is, as JJ said, an alternative mode of dispute resolution, alternative to state courts. It has particularly developed in international contracts. So if you had a case such as the one on the slide, and you do not have to read it in detail, a complex dispute with parties from several continents, arbitrators from several continents, and counsel as well spread around the world, you would think that arbitration is a perfect candidate for digitalization. And you would think that we've done it already years ago. But that is not exactly so. Until very recently, in an arbitration, you had at least once in an arbitration a hearing that took place, and all these people from all these continents had to come to London, Paris, Washington, DC, and so forth, and were sitting in one big room, as you see on a screen, something that would be unheard of today in view of the pandemic. And very rarely for big hearings, very rarely people raise the idea that this could be done online. Paper as well was used. So when you had people spread around the world, complex case, people were sending emails, but were also big submissions were sent by mail. And some offices looked like you see on the screen. This is not my office, just to clarify, but this is I got it from the internet. But paper was still quite present in arbitration. But yet, digital transformation in arbitration started already before COVID. And I will present 6 pillars of this digital transformation, and I will speak about it from my perspective, which is mainly, I work mainly on ICC cases, so cases administered by the ICC, International Chamber of Commerce Court of Arbitration, seated in Paris. When I started working for the ICC first back in 2007, emails already existed, video conferences already existed, and yet communication of ICC with users was by fax and by letters. Email was rarely used. Then it changed, in the next years, but that was 2007. We are not talking about 80s. Internal meetings of ICC staff were all in person, where we all had to discuss cases, at ICC staff meets to discuss all cases to make sure that the decisions are consistent. And these meetings took place in person, and everybody had to bring a pile of papers, everything that had to be discussed. So these piles were a lot of paper was used. ICC court is a body that has to take certain decisions, such as, for instance, whether to confirm an arbitrator or decide on a challenge. These sessions were traditionally held in person. Exceptionally, somebody would connect by telephone for a case. This changed, however, the moment ICC opened its first overseas office in Hong Kong, followed by other offices in New York, in Singapore, and in Sao Paulo. And the evolution of ICC arbitration and the fact that ICC court opened offices all over the world changed the way the ICC court met. And video, already as of 2010, was introduced, and most ICC court sessions were conducted in a hybrid form. Some people were in Paris and some were somewhere else. In general, in ICC cases, for many years, merits hearings or oral hearings were conducted traditionally in person, physically. And it was very rare that somebody would, as I said, bring up this idea, why don't we do it by video? It did happen sometimes that, for instance, if a witness was not, just hold my screen will, Up. Just bear with me. Up. I think it should be working. Sorry, it happens sometimes that, for instance, a witness couldn't come to the hearing because of an illness or visa problems. And then often parties would agree, why don't we just hear this one witness by video? But often the representative of the other party would go and be with the witness. So it was just really exceptional. Procedural meetings, such as case management conference, for years right now took place by telephone or video. So that is also encouraged by the ICC in its rules. In ICC arbitration, it's not only about case management. ICC organizes a lot of seminars and conferences. These traditionally took place physically. But ICC Commission, which analyzes the work of the court and to provide users with guidelines and feedback, ICC Commission for years has now talked about information technology in international arbitration and encouraged the parties to consider new available techniques in conducting arbitration. So what has changed in international arbitration since COVID? Well, arbitration hearings right now all look like this. You have a screen, sometimes you have dozens of people. In big exit cases, you can have more than 50 participants at a time, but a traditional case, you have just 10 maximum people on the screen. We had to adjust as well our offices. So in order to be able to have a hearing from home, you need to have at least 3 screens in order to look at the hearing bundle, in order to look at, see everybody's faces and to communicate with your team. So you need to be properly equipped. And this is a photo from a colleague of mine, Professor Saiz, who shared with me the photo of her own desk that she rearranged like this. So digital transformations took place already at home. I told you that ICC organizes conferences. Traditionally, ICC in April organizes its European conference in Paris. You have a big, beautiful room. People sit in this room quite close to each other. And of course, this year, this is how it looked like. It was online. And in the beginning, we were all sort of skeptical how it will work, but actually it worked super, super well. And there is a possible interaction and it works very, very well. So let me speculate about the future of arbitration. Will the digital transformation that was strengthened in the last months with the pandemic, will it last? And I have signaled four possible, again, pillars of this transformation for the future. The first point will be whether there will be more remote online hearings and meetings. There are several challenges that we have to deal with when organizing these remote hearings. And for instance, time zones is an important issue. If you have party who is in one party in Brazil, one in Paris, and another one in Asia, it's a challenge to find time during 24 hours where everybody's available. So that is a challenge. And so hearing dates are shorter, and then you need more days to have a hearing. We have seen that there are technical disparities. Not everybody has all this equipment. Not everybody has appropriate broadband. And so tribunals, when organizing remote hearings, have to address the technical requirements early on in order to make sure that everybody can participate. For that, often tribunals, it is now regular that in an arbitration prior to the actual hearing online, you have testing in order to avoid surprises. In recent months, we had to deal as well in Hannefeld as well, because we often act as arbitrators with objections to remote hearings. Some parties are used to the physical setting and so said that the online form deprives them of the real opportunity to present the case. but most practitioners, arbitral institutions have recognized that the remote form is appropriate and allows the parties to be actually heard, seen and heard, as you just hear and see me right now. Remote hearings also may lead to the reduction of time and costs. In terms of time, because arbitrators don't travel as much as they did in the past, they are much more available. So that can be actually save a lot of time, and it may be easier to schedule a hearing quickly, the same for parties counsel. And in terms of costs, unless you use very sophisticated providers such as Opus or Spark, you can just use Zoom, and it may not be as costly as that. So it may lead to reduction of cost in an arbitration. In terms of, I noted about the diversity. Currently, for many years now, we complain that in arbitration there's a problem of diversity, in particular with respect to arbitrator appointments, not enough women and not enough ethnical diversity. It has been suggested that the fact that we are now living in a sort of virtual world, there are no borders, means that maybe there will be more diversity in terms of arbitrator appointments, in terms of party representation. Maybe the party will think, well, I might try to get somebody from far away if there are no specific local issues to deal with. Choice of institutions as well. Maybe I know that already right now, for instance, some European parties consider that some European institutions are too expensive or too formalistic and go to Asia, for instance, without having any link to Asia. So perhaps more diversity with respect to the choice of institutions. And two more pillars in terms of teaching, conferences and seminars. This has changed completely in the sphere of international arbitration. All arbitral events like this one are held online. There is a challenge, I think, for students. Teaching is done online as well. I taught a little bit online as well. I find it a little bit, well, it's a challenge. I think the contact with the students is not the same. And I think for the students, it's also not as great as being in the same class with everybody, where interaction is probably better. So I think it's a challenge for students, and I admire students who continue to interact on the platform and try to take the most of it. Remember, in the beginning of my presentation, I showed you a pile of, a desk with piles of documents. Obviously, right now with the COVID in international arbitration, institutions and arbitral tribunals discourage the parties from exchanging paper documents. So on a long term, and so everybody gets used to it. Some people realize that maybe they don't need to receive so many submissions on paper. So maybe this will lead to arbitrations being greener. And I have put on the slide, there is an initiative that was put in place several years ago by Lucy Greenwood, maybe not it was made early this year, I think maybe last year. Lucy Greenwood, who has put in place a greener arbitration pledge, where practitioners from the sphere of international arbitration are encouraged to reduce the use of paper in their work. So I would speculate that the future of arbitration is that it will be much more digitalized and environmental friendly. Thank you very much.
All right. Thank you. Thank you, Maria.
Try to stop. How do I? Oh, no, it's here. There you are. I think. Now.
All right.
Thank you.
Thank you.
I hope I'm good in terms of timing. I wouldn't leave time for Janice and for discussion in particular. So.
Yes. No. I'm sure that I'm sure that's okay. Thank you very much. All right. So moving on. I'd like to introduce our next speaker. Our next speaker is Ms. Janice Lee. She's the International Dispute Resolution Counsel at Harry Elias Partnership in Singapore. She's a graduate of the UP College of Law in 2008 and she studied at the Xiamen Academy of International Law in 2011 and earned her Public International Law LLM, Masters of Law at Queen Mary University of London. She's a committee member of the Beihai Asia International Arbitration Center, and was for a time the Associate Counsel and Business Development Manager at the Singapore International Arbitration Center. She's a multi-qualified international arbitration counsel, having qualified in the Philippines, England and Wales, and New York, and has represented clients in cross-border disputes involving M&A, construction, and energy. She's well-versed in Singapore International Arbitrations and ICC arbitrations. Please welcome Ms. Janice Lee.
Hi, thank you. Thanks very much, JJ. And as I think I've mentioned before, JJ was also previously my professor in law school. So I hope that me being here in his webinar means he thinks that, he did something right. And he was spending countless hours teaching our class negotiable instruments. Right now, so I actually have a presentation on troubleshooting virtual arbitrations. So thank you also to Maria for providing such an excellent presentation and providing such a comprehensive look at virtual arbitrations. So what my task now will just be to look at specific situations in virtual arbitrations which may require certain new solutions, because these are the kinds of situations which don't actually appear in regular or physical arbitrations or physical hearings. I do have presentation slides, but unfortunately I'm not able to share them right now. Okay, there we go. I think I am now. Sorry, let me just share them now.
There you go.
Okay, perfect.
All right.
There we go. Can you see it?
Yep.
Okay, so I'm just going to do a very, very quick topic on troubleshooting virtual arbitrations. And really, as Ms. Maria showed, the interface in virtual arbitrations today is so vastly different from how we used to do, for example, physical hearings, where everybody comes into a room, everybody flies in to one location, particularly if you have, parties from different locations, counsels from different locations, witnesses and experts from different locations. It's a different kind of logistical arrangement. It's a different kind of coordination. It's a different kind of planning for a physical hearing than if you have a remote hearing. And really, one of the things that I see that when you move into this a different paradigm of virtual arbitrations is that in every stage of the proceedings, and you have here before the screen some of the usual stages that may happen in arbitration, there is really an opportunity to be able to adapt, to be able to make sure or to prime your arbitration for success. So for me personally, what we do is that as early as possible, you want to be able to agree with the other parties what you're going to do whenever certain situations arise. So one of the best ways to do this is to, for example, agree on certain protocols. So for example, you have appointed the tribunal, which is on the second part of your screen there. Usually the tribunal would, call for a case management conference just to set the entire procedural timetable for the rest of the hearing, for example. If you already know that you're going to be conducting virtual hearings, this may be a good time to try to understand what do the parties want, what are the parties' objectives in making sure that all of the flexibility is really taken advantage of. Before you proceed to an evidentiary hearing, for example, which is near the end of the proceeding, you can also have a pre-hearing conference. And again, these are the times when you can adopt different kinds of protocols, maybe cybersecurity protocols or e-hearing virtual protocols, just to make sure that everybody's on the same page and you're not running into situations which are completely unwelcome. And these I will turn to in the next slide. So what are these kinds of examples? Like I said, these are situations which you don't actually encounter in regular physical hearings. So one scenario would be when you look at, you already have, you've agreed to a virtual hearing because, everybody's locked down, you can't really travel, it's not advisable to travel, you probably shouldn't. And then you look at your applicable law or the procedural rules, and it says, or you look, at your arbitration agreement, and it actually says, oh, there is a requirement that the hearing must be conducted in person. And the issue here becomes, a problem, a potential problem of enforcement. It may be that if you go ahead and proceed anyway with the virtual hearing, you may run into an issue of enforcement because the other party, usually the losing party, will say, well, the arbitration was not conducted in accordance with the party's agreement. Of course, there are potential solutions to this. One would be you could obtain a party's consent to virtual hearings. You could check the law governing the arbitration, or particularly the laws governing the jurisdictions of enforcement. Maybe you consult local counsel and say, hey, if I enforce my award here, it was, and this is a scenario, is the court, or what is the court's approach to this kind of situation? And you check the applicable rules. So while it's great to have a virtual hearing because you do save a certain amount of costs and time, it may or may not be worth the risk of maybe potentially risking your enforcement. So that's really, it's really a question, it's a case-to-case basis. But that's one particular scenario that doesn't actually appear often in physical hearings, but which may appear in virtual hearing. A second scenario, a little bit more practical, is you have your ongoing virtual hearing and everything's all set up. You've already put into place, everybody's in place, doing making their cross-examination, and then suddenly the video or the audio feed cuts out completely for one side during the hearing. So, and while we think it's just a regular technical issue, yes, that's true, but at the same time, it could have certain due process implications. One of the parties may say, hey, you know what, I wasn't actually given the chance to present my case properly. It was unfair for me. I was deprived of this opportunity. That's one issue. Another issue is that cost. Because of maybe a technical interruption, you have to reschedule, you have to postpone a hearing. All of these would entail costs. Every hour, to be honest, that you spend a bit longer will entail additional costs for your counsels, for your arbitrators, for the service providers. So who bears those costs? Who bears the burden of when a technical glitch happens? And like I said at the beginning, it's really very useful to have a protocol or an agreement already to decide these kinds of things so that if they do come up, you already know how to handle them. At the same time, a possible solution is if something happens like this, it's really best that, if the tribunal doesn't do it on their own, one of the counsels will approach the tribunal and say, ask them to, quote unquote, cure the technical defect, maybe, adjourn the proceedings if you really cannot proceed with one of the parties being present. So these are the things to bear in mind. Another scenario, which is kind of similar, is if your video or audio feed gets hacked or it's hijacked. I think, in the early days of the pandemic, and then everybody was doing Zoom calls, we've had all these reports about Zoom bombing and people just suddenly showing up. And they're very inconvenient. But at the same time, when you have very high stakes arbitrations, the more serious consideration is that it could lead to a leak of confidential or sensitive information being leaked. It could lead to, parties being compromised. So you'd want to avoid these as much as possible. As I mentioned, you could have a protocol at the beginning, a cybersecurity protocol. Make sure you have sufficient encryption for all your information. Use a reputable service. Use institutions, because there are now a number of institutions which actually offer virtual hearing services, and most of them are reputable. And you can have them as a third-party neutral, be the one to control the proceedings and gatekeep the process. So usually you provide them with a list of certain people, and these are the only ones who are allowed to join the hearing. They're able to gatekeep the process, make sure everything runs smoothly. Another scenario is, for example, one of your tribunals, counsels, or witness experiences technical difficulties. So, this is similar to my earlier example, and this leads to an interruption or a break in the testimony or questions or instructions, basically interrupts the smooth flow of your hearing. And at the end of the day, it really just affects a party's ability to present their case. And again, there are cost implications, and it's at the minimum, is really disruptive to the proceedings. If you're if you're conducting your cross-examination and you're building up to a really good point, and then suddenly you have technical difficulties, it's really incredibly disruptive. It could break the flow of your questioning. It could break the way you were trying to arrive at a point, which could be very, very critical to your case. So as much as possible, it's great to invest in proper equipment, high-speed internet, webcam, microphone. The problem really here, sometimes you have witnesses or parties in remote locations, maybe sometimes not of their own choosing, they didn't want to be there, but they were constrained by circumstances. And if the witness is crucial, if it's a critical witness, you have to consider, is it best to just postpone the hearing? If one of the parties usually is in a place where internet is not always, connectivity is not always great, that's something to consider. Is it something that you want to risk just because you want to arrive at a resolution of your dispute maybe a few months earlier? So of course, there are no cut and dry solutions. You really have to take into account many different factors. Oh, and yes, so I put in here e-bundles. And I think that's a really great thing about having more virtual hearings, is that the use of e-bundles is a lot more prevalent now, at least I found, and even for smaller arbitrations where sometimes the cost of procuring an e-bundle service is not always, does not always justify the amount in dispute. But because a lot of the hearings have become virtual, and it's really encouraged the use of e-bundles, making sure everything is cross-referenced and everything is a lot easier to access for both the parties, the counsel, and the tribunal. So as much as possible, if you could have access to these kinds of services, it's really great to have them, and it could lead to, it'll avoid interruptions. It'll avoid, waste of time in looking for a particular document, especially if you have stacks and stacks of documents that you need to go through. Another scenario, which I think is quite interesting, is when a witness cheats, in quotation marks, by having someone in the room or having notes. So usually, it doesn't always happen. And most of the time, a lot of counsels, a lot of parties actually really want to protect their reputation, and they won't do this. But it is possible that you have a witness in a remote setting. Counsels cannot always control their witnesses. And usually, sometimes you don't know, they may look like they're alone in the room, but you can't see the other side of the room. You look like they may be talking to someone, and aren't they? And you don't want to cast aspersions unjustifiably. So a good way to avoid this, or to ring fence this issue, is when you can ask the tribunal, or the tribunal will usually do it on its own, that they'll confirm that the witness is alone, they don't have any notes with them. When you feel that there's a high risk of your witness being compromised, or the integrity of the testimony being compromised, some parties agree to have rotating cameras, or at least the camera pans towards the room at least once before the witness starts presenting. Or you can have, it's very practical solutions is really just to have maybe two cameras, one at the front, one at the back. There are many different ways, but the important thing really is to consider all these issues which may arise before they do, so that when they do arise, you already have a set mode of solutions that you can implement straight away. And lastly, I'll just go into, and I think Maria touched on this earlier, most of the time when you have, quite large arbitrations, it's really possible that your tribunal, your counsel, your witnesses, your experts are, across different jurisdictions, and it's really hard to schedule. And it's not only that, sometimes, if one of your witnesses, if you have witnesses who will unfortunately have to go on the stand at a time which is maybe 3 a.m. their time, it's really, there's always a human factor in arbitrations, and you can't escape the fact that it can be very difficult for them. It can be very taxing for them. Most witnesses have day jobs, and they could be very tired from a long day, and then you have a 3 a.m. witness examination. So as much as possible, you try to, if you're the counsel presenting that witness, you try to get a favorable timing. You try to shorten the hearings or multiple tranches, just so you make sure that your witnesses are protected, your case is presented well, you're not put at a disadvantage. So, of course, another thing is that as compared to regular physical hearings where you usually have everybody in the same room, you can keep tabs on everybody. There's also a possibility that your witness might not just show up because you don't have sight of them. You can't really control them, and it's possible they also have their own lives going on wherever they are, and it's really hard to keep them all in the same room. They may be online waiting for their turn to present. They may be in a breakout room, but they may be called away from their screens for whatever reason. It's quite difficult to administer all the time. So a good way of doing this is, again, proper scheduling, very, very meticulous planning, just to make sure that none of the witnesses or your parties even are left in the dark, or everybody's well accounted for all the time. So this basically wraps up the situations some of the situations that could arise in a virtual hearing, which don't normally arise in physical hearings. And as much as there's you want to be able to use the advantages that virtual hearings can have in order to resolve disputes quickly, you should also consider the pros and cons of virtual arbitration. There are many things that you don't normally encounter in physical hearings that you wouldn't even think of, but could actually arise in a virtual hearing, and then you just have to be prepared for them. Like I said, one of the best things is really agree on certain protocols even before you begin. Try to anticipate any potential issues, and otherwise I do see that there's a lot of potential for virtual hearings and virtual arbitrations in the future, particularly because time and cost savings, and I think, as Maria touched on earlier, the potential to encourage diversity in arbitration, which I'm always very supportive of. So that's all for my presentation for now. Thank you.
Thank you, Jan. So thank you. Actually, the both of you, I think it's the first time that we've had one of these events where both speakers spoke well within their allotted time. So 20 minutes. Congrats. Thanks. Thanks.
I think that we are both experienced. In arbitration, you have to comply with a very strict time limit. So I think you can see that.
That's a good one. So I just want to do, before we go to the Q&A, I'd like to invite everyone, if they have a question, if you're in the Zoom call, there's a Q&A button. Just post your question there. If you're following us on Facebook, you can post your question on the comment box, and then we'll get to that. In the meantime, I will just do a quick shout out to people who are joining us. I normally ask people where they're watching us from, and I do it north to south. So I'm happy to say that we've got people, Luzon, Visayas, Mindanao, so all over the country. So as far north, I believe, as Isabela State University from Kawayan, La Trinidad, Benguet, Baguio, Muñoz, Nueva Ecija, Pampanga, Bulacan, Quezon City, San Juan, Makati, Manila, Dasmariñas, Cavite, GMA Cavite, Cebu, Davao, and Zamboanga. So thank you for joining us. And I'm hoping, usually I have a friend in London who, if she wakes up early enough, she's able to join us. So having said that, I'm now going to change the view to a gallery view and have our speakers for our Q&A. And let me see. I guess I have a couple of questions. I don't see any questions yet from the audience. There's also somebody coming in from San Pablo and Santa Rosa, Laguna. People always try to catch up after you've done this. So anyway, okay. So I guess so in the next week, actually, we're going to have a session on trying to explore bootstrapping e-court or electronic hearings for trial courts in the Philippines, in Manila, and trying to do that on a shoestring budget. We're talking about, DSL connection or fiber connection with mobile phones, and just the basic setup and Zoom, and using Google Docs or Office 365 for case management, for filing, as well as for the hearings themselves. And so I think some of the problems that were raised in relation to that, Jan was mentioning about, witnesses being coached. So I think one idea that I heard from a provider was, you can have two cameras with the witness. You can have one camera pointed at the witness, and then you have another camera showing the entire room, right? So you can see if there's anyone else in the room. I don't know if that solves that problem. My question is, and I'm curious, is, so if the hearing is face-to-face, at the end of the day, there is a sort of paper records, right? Everything is somewhat reduced to, transcript, stenographic notes on paper. I don't know if if they take video, if that's part of the sort of official records of the arbitration. What are the official records of arbitration when it's done virtually? Will the videos form part of that? Okay, go ahead.
I think it depends on the technical option that you choose. So if you choose one of the very professional providers, such as Opus 2 or Spark, I think they include in their quote transcript from the hearing. So you will have an automatic transcript included in your invoice. Many of the hearings that we have done at Hannefeld were done simply by Zoom without transcript. Sometimes there was the agreement between everybody that the tribunal would record the hearing by Zoom, as you're doing right now, I think, and then would circulate the recording if it's necessary. But honestly, in many cases, and before even they were done virtually, at the ICC, I've seen many cases, not the big complex cases, but many cases go without the transcript. It's not necessary in each case because it increases costs tremendously. But for these big cases, you can have a transcript and you can also have simultaneous translation. So there are options for having that.
I see. Jan?
Yeah, I agree. So most of the arbitrations I've also been part of, we would have transcripts. But as for video recordings, I'm afraid actually most of the time the parties don't agree not to dispense with it, for whatever reason. So usually I would say if you can call it a record of the proceedings, it would definitely be the transcripts.
Okay, so if it's the video, I'm wondering. So in the transcript, if you you say, oh, the witness said this, and then you reference a page number. On a video, do you reference like the timestamp on when the witness said it, and then the tribunal goes back and watches that?
You could, but how often did you have it? So rare that you refer to certain passages from honestly, in arbitral awards, you usually have references to written witness statements, because that's the rule in arbitration. You have written witness statements, and then
right.
And so references to the actual transcript with respect to the witness testimony, it's very rare, but you could technically refer to the minute in the transcript.
Okay, there's a question here coming from the Commission on Higher Education, Legal and Legislative Service Attorney Frances Maysegi. She asks, what tips can you give to ensure efficiency and legitimacy of hearings?
I understand that Frances refers to these online hearings.
Yes.
I suppose so. It's a good question, but I think in arbitration, there were problems before in physical settings, and there are problems now. It's just that now it's a different form of problems. To avoid this and to ensure efficiency and legitimacy, you need to have a tribunal that is on the top of the thing. So in all these scenarios that were interesting scenarios that were presented by Janice, if you have a tribunal that has a courage and that takes strong decisions after having heard the parties. And if the parties feel that somebody's in charge, I think this will lead to increasing efficiency and legitimacy. But you need to have clear rules, and you need to obey to them, and you have to have a tribunal that actually enforces these rules. So I think it's possible, but depends a lot on the personality. So it's not, because we talk a lot about technical aspects, but I think the personal aspects, we are humans behind the screens, and we should not underestimate the personal aspect that is important in this digital world.
I must agree. In fact, you know, I think that in arbitration specifically, because of the flexibility that it has, choosing the right tribunal is one of the single biggest decisions you make when you're commencing or responding to an arbitration, ensuring that, you know, they're firm, they're competent, they know what they're doing. Like Maria said, they're able to enforce their procedural rules or procedural directions. They're on the ball all the time. And I can't tell you enough. I've seen, you know, cases where the tribunal has been a bit lax, and it really sets a tone for the entire arbitration. So if you want an efficient arbitration, you have to get a good tribunal. You know, of course, to a certain extent, an arbitral institution also plays a certain role in making sure that, you know, proceedings are quite efficient. They, you know, go along quite fast according to the procedure. But I think tribunal is really, really key.
Okay.
If I can just jump in, it's a very important point. Institutions, Janice referred to when the COVID started in Europe in March, ICC, for instance, court, and other institutions as well, but ICC court issued a very detailed guidance note whereby it encouraged the parties to consider using remote hearings in arbitration. And the fact that the institution endorsed it legitimized in a way these virtual hearings. But now in January 21, new ICC rules enter into force that actually have virtual hearings in the rules as an option. So that's additionally, but the role of institution, I couldn't agree, role is also very, very important.
Okay, so I have a question in relation to, you know, my understanding of arbitration is that the underlying basis of arbitration is the consent of the parties. The parties agree to arbitrate their dispute. Have you had a situation where one of the parties is ready to engage in online or virtual arbitration, but the other party refuses? And under what circumstances do you, I mean, I guess, what would be the remedy of the party that wants to proceed with arbitration?
I'll let Janice start this time, maybe.
Actually, yes, I specifically had that particular situation. We had an arbitration hearing scheduled, you know, during the lockdown. We discussed among ourselves that we don't, particularly for our side, we did not want to prolong the proceedings. We did not want to delay it. The other side seemed to insist that they wanted a physical hearing. So there was a lot of back and forth because we were saying, you know, you don't know when the lockdown will end. At this time, everybody, each and every one of the parties, the councils, the tribunal has sufficient technical capability, so we can all just proceed. To be honest, what happened there, we just, you know, kept discussing, and then we raised it to the tribunal, and then we, you know, gave our submissions on, you know, very, very short submissions, we argued that we wanted to proceed with a virtual hearing. The other side argued otherwise. At the end of the day, it was the tribunal who decided, you know, we can, he gave a very, I would say, very balanced decision. He said, if at this point, and he named the date, the restrictions have not yet been lifted, then we will proceed with the virtual arbitration. If they have been lifted, then we can look at physical hearing. So, you know, that's what happened, particularly in one of my cases. So it really, you know, there was a lot of back and forth, there was a lot of discussion. We didn't force the issue, but we did make sure that it was heard by the tribunal and there was a decision made on it.
At Hannaford, we had several cases. In Hannaford, we often act as arbitrators, and so and as counsel as well. But in cases where we acted as arbitrators, it was very important when you have a disagreement for the tribunal to issue a very comprehensive decision. And here, sometimes what I that we have seen is sometimes the parties raise objections that are not very concrete. They say, this is the breach of our right to be heard. This infringes the law of the seat, without concretely saying how the breaches. And so in many cases, tribunals indeed said that, well, under the whatever rules, like ICC or others, we have the procedural power to manage the case, including to opt for virtual hearings. The parties will be able to present their case. I think I can do it. And so in these cases, again, it requires a certain courage from the tribunal. But in many, I think over time, the reaction in March and April, everybody thought that it would be over very quickly. So indeed, many parties said, well, we want to wait. And there it's delicate for the tribunal. If both parties say, we want to do it physically, I don't know, in March 21, I think there is little option for the tribunal other than saying, are you sure that you're okay with this delay? So if both parties want to have a physical hearing, I think it's delicate for the tribunal to say no if there is no power in the rules to do this. But if one party objects without good reasons, if I may say so, I think it's okay. And it's interesting to follow as well jurisprudence of state courts on that point. There was recently a decision in Austria where Austrian state Supreme Court decided on objections that were based on the fact that there was a virtual hearing conducted where one of the parties disagreed. And state court said, no, it's fine. Tribunal had the right to order this form and the party's right to be heard was respected. So I think with time, we will get used to this form and I think it will become more normal. Thank you.
So that's very interesting. There's so many questions coming in. There's actually somebody who said he's coming in from Melbourne, Joe Pat. So we have how many continents is that? So we have Asia, we've got Europe, we've got Australia. So we're international today. So I think the objection, if I'm just following on the discussion, I think the objection would be, could the party say, when I agree to an arbitration, my consent was to a face-to-face arbitration, and that I did not consent to this kind of arbitration, and you're forcing me to engage in a kind of arbitration that I did not anticipate. Now, I guess that argument can be put forward. And my question, and I think the question is, how do you think the courts are going to address that if the authority of the or the award is challenged?
Well, I think, and maybe our friend from Melbourne can comment on this, but I think very early on, Australian courts addressed this point as well and recognized the possibility of virtual hearings, and other state courts as well. State courts, by the way, outside of arbitration have conducted hearings virtually already, even in my home jurisdiction, Poland, and in England, in Ireland. So there are many countries in which state courts have done it. So I think, we can anticipate that in these jurisdictions there will be a positive attitude to that.
Janice?
I think, if one of the parties say, you know what, I always envisioned having a physical hearing, then to be honest, it's very rare that you actually find those specific words in an arbitration agreement. So it would be hard for them to actually prove that as, that I wanted a physical hearing, I'm entitled to a physical hearing. There is really very little basis for that. They are entitled to be heard. They are entitled to a fair opportunity. All of that, absolutely yes. Does it always mean a physical face-to-face hearing? I would say no. Of course, as I think I mentioned earlier, sometimes you do have to check applicable rules. Sometimes, maybe the law of the seat or the law of where you're going to enforce the award actually takes an opposite view. So if that were me, I would consider those factors first before proceeding anyway with a virtual hearing.
But you're right, Janice, it's very rare that the clause says the hearing will be physically because nobody thought of it before. But we see often we often see clauses where the clause provides for arbitration will take place in Paris.
That's true.
Usually we would interpret it as the Paris as the seat of arbitration, sort of the legal regime, the legal passport of arbitration. But one could argue that if the arbitration clause says arbitration in Paris, that means you have to go there. So that might be tricky. And their tribunal would just have to do what it always has to do, interpret the contract as well.
Or actually, sometimes what I do see is arbitration in Paris, and the hearings to be conducted in, and then they name a place. So while they don't explicitly say physical hearings, it is sort of implied that you conduct the hearing in a particular location.
Right.
But if you have rules such as LCIA and new ICC rules, so you have arbitration clause that refers, for instance, to LCIA. LCIA provides that the tribunal can order virtual hearings. Then you consent to the fact that even though you say in your clause, hearing in Paris, you consent as well to LCIA rules that say that in any event, tribunal can order remote hearings. So it's not just what's in the arbitration clause, but you also have to look at the rules.
I think it's a good rule of thumb that it's not enough for you to raise an objection, particularly very technical objections, without demonstrating that the denial of a face-to-face hearing somehow impairs your ability to present your case or present some extreme hardship, or is just on the issue of fairness, right? It would be unfair to hold the hearing virtually. And I think it's very hard to make that case. I think there's so many benefits. Cost is one of them. You don't have to travel to the place of arbitration. So I think this is going to create some sort of tension. If now the tribunals are forcing virtual hearings, I wonder later if the question will be flipped, where the tribunals will force face-to-face hearings, right? And parties will demand to meet face-to-face. What do you think?
Well, apparently many users actually want to go back to this. So there were surveys, and apparently many in-house counsel and us counsel want to go back to this. I think we all miss traveling. So I think the first month after the vaccine, we will all get on planes, but maybe at some point we will try to find a balance. But I think now everybody wants to meet again.
Right. So I think who wouldn't want to spend a week or two in Paris, right? It's an excuse. It's paid for by someone else. All right. There's a technical question from Joe Patch from Melbourne, and he asks if there's a recommended software for virtual hearings. He's heard that WebEx is a preferred platform. Have you seen that?
Well, if you look at there's a list of preferred platforms that is contained in ICC guidance note, and ICC guidance note refers to Zoom, WebEx, Skype for Business, Blue Jeans, I think, but I think in Europe we generally use mostly Zoom, WebEx, I think a little bit less. Depends as well on whether the platform allows you to have breakout rooms and so forth. But then for big cases, you have the special providers, Opus 2 and Spark, that are a little bit more, but the choice of the platform is something that has to be decided. And you have on the internet, you can find many options, comparative tables as to what platform offers what options. So that's quite interesting.
I think for small to medium-sized cases, Zoom is actually quite okay. I think as long as you have as you mentioned, the breakout rooms functionality, you have sufficient security protocols, Zoom is fine, WebEx, Blue Jeans. I think Maxwell Chambers in Singapore, for a time they offered Blue Jeans as well as Zoom. So it's really up to, at the end, maybe users' preference as well.
There may be an interesting issue, but just to raise it, of data protection. It's Zoom, confidentiality on Zoom may not be always ideal, and Zoom servers are in the US, and it may potentially be an idea for objecting that you're not sure who can actually control your personal data.
Okay. Actually, I had a question. Oh, so you've been using Zoom. I wonder if any of you have had experience, Zoom bombing or any of those things that I personally have not. But I wonder if any of you had experienced any of the security issues that were raised earlier. I mean, earlier, a few months ago, prior to the end-to-end encryption, which they've implemented already.
Thankfully for me, no, I have not
Me
seen
neither.
wanted images in my hearing, so very happy about that.
Me neither.
All right. There's a question here from Albert. Only if you know how, if you know, are you aware how the cybersecurity issues are being addressed in digital or virtual arbitration?
Usually now in the protocol, you have a paragraph on cybersecurity, but the idea is not to have a very complex cybersecurity protocol for each case. If it's a case about, I don't know, delivery of, I don't know, fruit from Poland to Germany, which is not a very sensitive, not a very political case, you probably don't need to have a very sophisticated cybersecurity protocol. Nobody cares. But if you have this very complex case, like the one that I put in the beginning on my slide, pharmaceutical with very delicate also personal data, trade secrets and so forth, so what usually happens is that the tribunal would put for the parties a paragraph saying that it is for the parties to determine if they need to have increased cybersecurity protocol, and if that happens, they may be something. Usually tribunals just put it on the parties to tailor make cybersecurity measures to the case. But my personal experience at Hannaford is that in most cases it sort of goes well, because what Janice said in the beginning, everybody sort of behaves so most users are very professional, so you sort of trust each other. So my experience is that unless there are good reasons, you just do the strict minimum. But maybe we should change this. I don't know, maybe Janice has a different view.
I think in our experience, it's also the same. So far, even with smaller or larger cases, we've been quite maybe fortunate that we've been dealing with quite reputable counterparties. So we've done we've had cybersecurity protocols, but they're not as extensive because we didn't feel the need for them, because maybe some of the information wasn't as sensitive, or there were other means of securing the information. But as to your question as to whether maybe in the future these would be much more developed, I actually do think so. The longer that this situation goes on, the longer that we have to rely on virtual hearings or events or everything that requires information being passed along virtually, I do think cybersecurity protocols will have to be much more well thought out, much more complicated.
And it's also due to data protection. We have to remember that data protection is very important. In Europe, we have a very strict regulation, but I'm sure we are not the only ones. And in order to ensure adequate data protection, you need to have technical means to protect this data. And I think it may lead to us needing to think about cybersecurity much more than we did until now.
Absolutely.
So,
yeah.
No, go ahead.
Just one point, in arbitrations, the amount of personal information that is actually personal data that's actually being exchanged across tribunals, across councils, across parties is really staggering. And I mean, I don't know, Maria or JJ, how you view this, but personally, I think it's a long time coming that data protection in international arbitration has to be focused on a lot more than it has been in maybe the past decade.
Yes, well, so the Philippines, like Singapore, we've adopted a GDPR-based regime. I've always, way back, I guess many years ago, because the European data protection law was actually put down in writing much earlier. And prior to GDPR, I believe it was the directive, which was in 1995. And I think, because many legislatures are like the Philippine legislature, were perfectly happy cutting and pasting somebody else's legal regime. So I think the European regime it was inevitable that globally the European, the EU, and now the GDPR will form some sort of global standard when it comes to data protection. And I'm happy to report that people in the Philippines do take data protection seriously. In fact, even government agencies are required to comply with the law. So So we're getting there where it's not 100%, but I think we're starting to build that culture of privacy and data protections. We're taking that very, very seriously. Now, I'd like to shift a bit. The Philippines is an outsourcing hub. So we do business process outsourcing. We're one of the major call center operators in the world. I think there was a time when the number of seats in the Philippines exceeded that of India. And I'm wondering whether if virtual arbitration is something is going to become the norm, if firms would have the need to say, or make it easier actually for firms to have cross-border teams, right? And then collaborate on this kind of arbitration, particularly those that involve complex issues. Do you see that sort of cross-border collaboration happening?
But that has been happening for the past dozens of years. I mean, as much as I worked, whenever I worked in a Polish office, I would work with offices from other countries. When I worked in a Paris office, I would work with London, Warsaw, New York, and so forth. So in arbitration, because JJ, of the scheme of arbitration, that you have so many jurisdictions, that what I showed in the beginning, so many jurisdictions, so many legal issues involved, it's natural that you have this cross-border cooperation already.
I mean, I agree. And I think to your point, JJ, as to whether this kind of digital transformation will maybe spur this along, perhaps it would, because it would increase communications between across jurisdictions, although as Maria said, it has been quite ongoing already, even before the pandemic.
Okay, that's good to hear. So I guess we'll be seeing, I mean, I guess it might be a cost issue and for, I guess, other reasons. But I think one of the benefits of the pandemic, it has been established that people can actually work remotely. Even my own office, I was resisting. We're a tech firm, a tech boutique firm, but I was resisting work from home. I said, no, I don't want people working from home. It's, and it turns out that it can be done. People are productive when they're at home. I think there are benefits to going to an office. There's still the benefits of having that and the interaction, the live interaction. And I think that's the reason why, Maria, you mentioned that there's going to be a lot of traveling after restrictions ease up and the vaccine is in place. I think people still want the face-to-face. I remember there was a statistic before that, even though sort of this is way back maybe in 2005, 2006, where they're saying even though remote connectivity is at its highest, in-person conferences were the largest that ever been. Now there's people, even though they can communicate remotely, really prefer the face-to-face interaction. So I think when things ease up, might take a couple of years, but eventually there will be some, and it might end up with some sort of hybrid. There's a question.
Just one interesting short comment, because it's something that Janice referred to, the physical hearings. An important point that you're lacking in a remote hearing is contact with the other side, because sometimes you can settle during the hearing. Sometimes, you meet in a corridor, something happens, and there is a possibility that occurs, which is much more complicated in this virtual setting, perhaps.
That's true.
Maybe I'm traditional, but that's what I heard as well from many in-house counsel.
I agree, and I think you're touching on, there's always a human aspect to everything that we do. And while many functions can be transplanted to a virtual environment, things like that, like meeting meeting your counterparty in the hall, just deciding, let's just settle this once and for all, things like that. It'll be very rare, and I'd be very surprised if it happens in a virtual environment.
Well, one of the things that I think is on the roadmap of Zoom, there are breakout rooms.
Yeah.
And my own complaint is that why can't there be breakout rooms and I decide which breakout room I have to go into, right? In other words, if they can make breakout rooms and people can choose, right, have some sort of autonomy going in and out, that way there could be like a virtual coffee room where people on break, right, can just go and then they can talk. And that could be sort of the venue. That could be the equivalent of the hallway where the deal could be struck. And so while the higher ups can go, why don't you send a flag out, send a guy to send a representative to the caucus room where they can do that, and that would be helpful for things like mediation, right? Where caucus is an important aspect of the process. So I was wondering, I think I'm running out of questions.
Question.
Go ahead.
No, there was a super interesting question by Albert Lee, another one.
Yeah.
In terms of witness evidence, how would you address the credibility of evidence witness heard remotely, relatively unsupervised? And I think that's linked to, I think that was one of the scenarios of Janice. I think in arbitration, there's this sort of inherent trust. So in many cases, you just assume that people are not cheating. If there are good reasons to suspect something, in some cases, you would send actually a representative of your team to sit with the witness and control. So that happens, and we've done it, and we've seen it as well. All this 360 camera, this have been these professional, for instance, when you have I've spoken to an expert who had testified, he had received the whole equipment with cameras, 360 cameras. So the provider, he received all the equipment, so he had no, it was just, he had to just sit in a room alone, but he couldn't even use his own equipment. So, but it's really rare. You just assume. There's an interesting topic that was raised back in the beginning of the pandemic, that it's much more difficult to assess credibility of the witness from the screen. But then, who I've never at the ICC, and I've read hundreds of awards at the ICC, never did I read an award that would analyze the face of the witness during the hearing, or whether the witness was sweating or not, or how the witness held his or her hands. Nobody does that. Nobody. You look into the words, what actually the witness is saying, whether it's coherent and consistent with on the file. So this sort of emotional analysis is rarely. It's interesting from the psychological point of view, but I think it's rarely relevant.
I think at most, that concern can arise when you're the one doing the cross-examination of your witness, your counsel. So you want to be conscious of how the witness is reacting. And in that sense, I actually found that the virtual setup was quite useful, because you actually have the witness front and center and you could see everything. So in that sense, it was even more helpful as counsel when you're examining, or even on defending your own witness. It was quite helpful having the screens put up in the setup that you actually showed us, Maria, earlier, with the multiple screens over there. It was quite helpful having everything right before you.
Okay, actually, you mentioned about I remember watching this documentary that was made during the pandemic, and they had to interview people. And what the filmmakers did was they left a package at the doorstep of each of the person they wanted to interview, and it's in a box or maybe like a suitcase, right? So they get it from their they bring it inside their house, they set it up themselves, and then there's a screen and there's a mic and there's a light and everything's all set up. They just turn it on and then they start talking. And I think that's the sort of setup I think that Maria, you're mentioning, where the witness has no control. Either that, or he walks into a room and everything's set up, no one is there, and everything is set up. The screen is there, and everyone goes, and he doesn't control the situation. And there could be another camera somewhere else, and maybe that can result in better testimony. Now, I like what you mentioned
but
about,
it increases costs, huh? So it's
yes,
not necessary for each case. So let's not encourage it for each case, because it increases costs.
Yes, I like that you mentioned that the arbitral award rarely, or I said never, describes the witness and whether or not that the witness should be believed. I think I would think that if I were an arbitrator, it would be difficult to put that in an award, because then you could be judged for that, when it's much easier to say, well, we believe this side more than that. Or on balance, when you're writing something, you can just say, on balance, the evidence was more convincing. as opposed to saying that, the case, rose and fall on the way the witness answered. Although if that person was the star witness and the performance was so bad, maybe the tribunal can put that into question. But they can also just focus on what he said. And I think it's better to focus on what the witness said rather than how he said it, because it might be hard to put that down and use that as the legal basis for a finding.
But I mean, I'm not saying it happens, of course, that in awards, tribunals assess credibility of the witness. What I
Yes.
said, that this credibility is not based on, analysis of mimics or facial expressions or whatever, but it relates to the contents. Huh?
Yeah. All right. So we're coming up to unless you see any question that you'd like to answer. There's a question about from Albert about Albert Lee about illness and whether or not arbitrators have had to excuse themselves because of the pandemic. Has that happened?
I think of course, arbitrators in council, we're all human. We all do get ill from time to time. So, usually the parties just rearrange their schedules. They're quite understanding, particularly if it's an arbitrator. You can't really replace them just like that. So you do rearrange the entire procedural hearing, the timetable around them. I'm not sure if your question was whether you've had an experience where the arbitrator was ill of COVID. I personally have not heard of one. Of course, it may, be very confidential. So, no.
Yeah, personally, I've not encountered it. And then you have several COVID forms. Huh? So I've heard of people who had COVID but continued working because sometimes you don't have symptoms.
Yes, seems that a large percentage do not exhibit the symptoms. Okay, so perhaps just in closing, I think this is a question that's already posed before, but I'd love for you to answer. What do you see for the future? Is this mechanism in part or a mix or a hybrid? Is this going to become the norm post-COVID?
I think so. It's difficult to speculate the numbers, as I said, and I think in the beginning there will be a wave of physical meetings because we all crave for human contact. But I think on a long term, we will do what we never really did in arbitration. We will ask ourselves the question. We will not assume that the rule is a physical. The rule would now be that we will talk about it. So I think the fact that we opened ourselves up to this opportunity will do that. It will result in more hearings being conducted in remote form. But I do think that for many hearings, we will maintain the physical setting because we just like to be with each other.
On my end, I actually think that having all these virtual hearings and a lot of it being very paperless, I actually think it's a long time coming. I wish it didn't take a pandemic for people to realize that it was very possible and very cost efficient. For us, because we work mostly as counsel, it's also really client driven. A lot of the clients, when they realize, I don't have, there's a lot of savings here, I don't have to fly you everywhere, they actually enjoy it. So to the extent that it helps the case, of course we would say, sometimes we do need a physical hearing. Sometimes there's just no going around it. But insofar it's client driven and it saves parties costs, it makes things a lot faster. I do think virtual arbitrations will definitely be here to stay.
So there's even within arbitration, which a lot of people already consider to be very efficient, you find that there's even more efficiency that's driven by this.
Yeah, I think so. It required many of us had to learn things. Like a year ago, I had no clue what Zoom was personally. So we had to and I find that the young generation adjusted much quicker than I. I mean, I was super proud of myself that I managed to use Zoom, whereas my son had a meeting with his friends and he said, well, Mom, it's obvious. So I think for the younger generation, this digital revolution in arbitration will actually make it perhaps easier because they're much more comfortable in this digital world than maybe the us.
All right. Yeah. All right. So maybe I can ask some parting, some closing words, Jan, and then Maria.
Well, for me, that like I said, I do think that there's a lot to be said for virtual hearings, virtual arbitrations. I do think that's where we're going. Maybe not 100%. So if you are, considering having your hearings virtually, if you are considering either changing the paradigm of how you're going to resolve your dispute, again, as I mentioned at the start of my presentation, preparation is always key. It's always great to discuss everything, anticipate all the potential issues, and then you could hopefully, expect a smooth a smooth running proceedings before you, and make it as painless as possible for yourself, your client, the tribunal. So planning.
Thank you.
And in terms of, it's also an interesting point how this digital revolution affects our communication in terms of building up our business. How do you talk to clients like this? How do you get new cases? So I think
I think the internet.
Yeah.
Are you there, Jan?
Yes.
I wonder if it's me. Oh, okay. So
might have stalled a little bit, which
I think stalled a little bit. She's out there in Paris. Oh no. Let's wait for her a second. Anyway, I'd like to take this opportunity to thank you. This is your second appearance here, and it's our second show on arbitration.
Thank you.
We're very grateful for your help in putting this thing together, and for inviting Maria. Boy, it seems that looks like she's logged off.
Probably log back in a bit usually.
Yeah. Okay. So I think I get the sense also that this is the future. I think like everything else in the pandemic, the digital transformation wave, as it were, has hit everyone, and this is what we've seen in your space. It's very interesting to see those changes and all the adjustments that has been made. It's comforting to think that this has been embraced by the arbitration community in a way that sort of moves forward arbitration. And for a lot of people here in the Philippines, it's not that common. I think for many people, and I hope that the example that virtual arbitration has shown us is something that we can sort of look forward to moving forward. I'm wondering. Go ahead.
You have an upcoming webinar on court hearings going online as well, I think, if I'm not mistaken.
Yes. So I'm wondering whether we should wait for Maria, but I think we're running out of time. So I'd like to thank you, Janice. I'd like to thank Maria as well for joining us today. This was such a great session, and as Janice mentioned, next week, actually tomorrow, we have a Digital Transformation Thursday on a Friday, and we'll be talking about the open access in communications in telco. So we're talking about the internet, the speed of internet in the Philippines. There's a bill in the Senate, and we have Dr. Grace Mirandilla Santos tomorrow, and as well as Attorney Roy Ibay from Smart Communications, and Professor Oliver Reyes from the UP Technology Law and Public Policy Program to talk about that. Next week on December 3, we will have Professor Oli Reyes again, and Professor Mike Chu of the UP Law Center, and Harold Martinez, who is looking at a provider for online hearings. They will talk about the court resiliency and the possibility for court proceedings to be done electronically using the current methods that we've discussed in an earlier paper, actually, about that. So thank you. This has been, I guess, another fruitful session of Digital Transformation Thursdays. We'll see you next. Right. All right.
Okay.
Thank you.
Bye.
Bye-bye.